Well, lodging a workers' compensation claim, Chris, is quite simple. What I would suggest you do in the first instance is report it to your employer.
Mm-hmm.
The reason being is, and I'll give just a brief example, you slip over at work, you think it's quite innocuous, it's not really painful at that point, but then 3 weeks later you start to develop more significant symptoms,
Mm-hmm.
Reduced range of movement, you can't bend, and you're thinking, I think that relates back to when I fell 3 weeks ago. Once you lodge a claim, your employer's going to turn around and likely say, we were never told about that, this could have happened elsewhere. So the most important thing would be to report it to your employer. The next step I would suggest is to go see your general practitioner, report it to them, let them know exactly what symptoms you're experiencing, and ask for a workers' compensation sickness certificate. And once you've got that, then you've got 2 steps to officially lodge the claim. There's 2 options. So the first one would be contact Return to Work SA on their phone number and go through their phone lodgement process. The second step would be to download the Return to Work SA claim form off the Return to Work SA website, lodge that together with your work cover certificate to your employer, and then they've got the obligation to provide it to the relevant insurer.
Okay.
It does. So I'll separate this into 2 categories. There's physical injuries, then there's psychiatric injuries.
Right.
So with regards to physical injuries, the injury must have arisen out of or in the course of your employment, and employment needs to be a significant contributing factor of that injury. So that's for a physical injury. Psychiatric injury, slightly different, the wording. Again, it needs to arise out of or in the course of your employment, but this time the psychiatric injury needs to be the significant contributing factor. So if you satisfy those criteria and you're deemed to be a worker under the legislation, then that's what you need to have an accepted claim. So the legislation which governs the workers' compensation entitlements in South Australia is the Return to Work Act 2014. And under this legislation there's 4 main entitlements. The first one being weekly payments of income maintenance. Now weekly payments of income maintenance are there to effectively compensate you whilst you're incapacitated for work. So the first 52 weeks following the injury you're compensated at 100% of your average weekly earnings. The subsequent 52 weeks you're compensated at 80% of your average weekly earnings. And then it stops after that. Unless you're deemed to be a seriously injured worker, in which there's a threshold that you need to meet to be categorised in that fashion. The second entitlement is for reasonable medical and like expenses. So effectively the threshold in order to show that your medical expenses are reasonable, it's quite simple to get over. It's basically if your general practitioner refers you for that treatment.
Right.
So things like physiotherapy, medication, all that type of conservative treatment, as well as surgery. So that's the second entitlement.
The third is?
The third entitlement is for rehabilitation services. So an injured worker is able to request for the insurer to perform what's called an activities of daily living assessment. So what they'll do is they'll engage the services of either an occupational therapist or a physiotherapist. They'll come to your home, they'll do an assessment and see what kinds of aids or services that may assist you in your recovery, including wheelchairs, ramps, rails, cleaning services, all those types of things to basically assist you in recovering from your injuries. And the fourth entitlement is lump sums for any permanent impairment that you sustain.
Right.
So for a work-related injury, each person who has an accepted claim is entitled to have 1 assessment per claim. This is called a permanent impairment assessment, and it's performed by an accredited doctor for each specific body part. They have their accreditation for each specific body part.
Okay.
Effectively, once your injuries are stable, which in my experience generally happens after 12 months, or alternatively 9 to 12 months following any significant surgery, you attend this appointment, the doctor performs the assessment on what your permanent impairment's going to be, and they give you a score. That score is called a whole person impairment score, and it's dependent on that score what kind of lump sums you're entitled to. The first one's a lump sum for non-economic loss, and that's if you achieve a score of 5% whole person impairment or greater. So I'll just throw out an example. A 35-year-old who sustains a left shoulder injury in 2017 and is assessed at 10% whole person impairment is entitled to a non-economic loss lump sum of $21,710. The second potential lump sum that you're entitled to is for economic loss. Now that's if you score a whole person impairment assessment of between 5% and 29%. This lump sum takes into account your age at the time of the injury and the hours that you were working. So I'll throw back to the example I've just used. So that 35-year-old with a left shoulder injury sustained in 2017, who was working full-time hours, is also entitled to an economic loss lump sum of $38,894.40.
Okay.
So that 35-year-old who had that injury, in total for lump sum under the work cover legislation, was entitled to $60,604.40.
Wow. Okay. Still not a lot in some.
Oh, look,
people's
it's
mind.
in some people's mind. Look, some of these injuries are quite catastrophic, and they significantly inhibit your ability to perform your domestic duties, your employment duties. But unfortunately, that's all that we've got available to us. It is quite a complex process. It is a process that an injured worker can do on their own, but due to the complexities, I would recommend getting or seeking some legal advice in respect of those assessments. So if you have a whole person impairment assessment of 30% or over, you still get your non-economic loss lump sum, but you don't get the economic loss lump sum. And the reason being is that you are now categorised as a seriously injured worker and you receive the benefits of being a seriously injured worker.
Okay.
So those benefits are effectively, there's no limitation on how long you can be entitled to ongoing payments of income maintenance. So effectively, if you remain incapacitated to retirement age, they'll continue to pay your wages until then. There's also no limitation period on medical expenses, and you can claim them for the rest of your life for the injuries that were accepted.
Okay.
So the recently amended work cover laws in South Australia have imposed an obligation on pre-injury employers to provide suitable duties to an injured worker consistent with their medical certification. This can be defended by an employer, however, if they can show that it's not reasonably practicable to provide those duties. And there's a variety of different reasons why. For example, if there was a complete relationship breakdown, if there's performance management issues, or if they can show that it's at a significant economic disadvantage to continue employing you. But there is that obligation and that threshold that they would have to get over to defend their claim for you requesting those suitable duties. So I would encourage anyone who's who's requesting their employer to provide them suitable duties and they're rejected to contact a lawyer and seek legal advice.
And of course those lawyers would be Johnston Withers lawyers.
I would agree with that.
Dominic Nasone, workers' compensation lawyer, thank you so much for this morning's chat.
You're welcome. Thanks for having me.